Hello and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. In this particular set of videos we are talking about the CSPA, the Child Citizenship Protection Act, and how it applies under different situations. And we've spoken about the immediate relative petitions. But remember, an immediate relative is defined as a single son or daughter under 21 years old. But what happens if the child is married and under 21 years old? Well, they're not considered an immediate relative. Now, let's say that a U.S. citizen father petitions his daughter uh, to come into the United States. Well, if the daughter is married, that's a third preference petition. Now, what happens if the uh, daughter, son or daughter, gets divorced? Well, under the CSPA, if the son or daughter gets divorced before the son or daughter is 21 years old, then that son or daughter then becomes an immediate relative again, and under the CSPA, and the age locks for CSPA purposes. So, for example, let's say that you have a daughter that married when she was 20. Let's say she married when she was 18 or 19 years old, and things didn't work out. And let's say you petitioned her at the time she was married, and it was then turned into a third preference petition. And let's say she gets divorced when she's 20 years old. Okay, the moment that divorce is final, she then turns back into a child for immigration CSPA purposes, and the age locks in. So when she gets divorced and she's 20 years old, and let's say the petitions go forward, and years later, everybody else comes in to the United States. Well, because her age locked when she was 20, because she got divorced, she is considered a child, an immediate relative child for those purposes, and is able to come in. So while I'm not advocating for divorce, if things aren't working out and divorce is imminent anyways, of course make sure that that gets done under these circumstances before the child turns 21. Okay, more in the coming videos.